Labour Cabinet Secretary Simon Chelugui has given some insight on how the issues of retrenchment, unpaid leave and more will play out.
We as the Ministry of Labour, together with the CAS and the PS and the whole team, we have engaged in high-level social dialogue with employers through FKE and with employees or workers through KOTU. And what we are saying is, for the first 30 days of this problem, let us engage, let's allow people to proceed on normal leave. So they will get their pay, they will proceed like normal. Then if this thing persists, then the next 15 days we can extend. Some employers are saying they can extend by another 15 days.
Now, let's look at some of the legal aspects that stick out in this unfolding situation. And definitely have to give credit where it's due, Irene Kashindi, who gave me some of these insights from law. The employee writes what the law says. And first things first, and on the issue of salary cuts, which has actually hit quite close home, as you will hear later in this bulletin. It is here at the Nation Media Group. But this is what should happen. In line with the sections 10, 5 and 19 of the Employment Act, for instance, an employee's remuneration should not be reduced unless consulted and there is consent given to this by the employee. So there must be something in the lines of a document that would be signed to say, I agree with the terms. But to the other scenario that could be drawn here is unpaid leave. And in this particular issue, there is no statutory or constitutional provisions on unpaid leave. Few judicial interpretations by the courts on unpaid leave. For instance, here at the Nation Media Group, it was used as one of the scenarios that could be a case where I would go on leave, still be on duty somewhat, working from home, given that we are providing an essential service, but this will definitely be taken off as an expense, given we are paid during the leave. And on to another scenario here, and the time limits that should be given on all these conditions that are being drawn. And following Article 41 of the Constitution, a salary cuts, unpaid leave should be limited in time. Where possible, a promise for long-term improvement or reimbursement once the operations normalize. So it shouldn't just be an open-ended kind of scenario. And to the issue of redundancies, if after everything has been tried and this COVID-19 pandemic continues with no end in sight, the redundancy scenario, now in this particular case, in line with the Employment Act, employer must demonstrate that the business is indeed affected by the pandemic in order to justify a redundancy. There must be issuance of requisite notices to the individual employees and unions where applicable, and there must be payment of redundancy dues. And on to something that many might have to go to, and that is legal recourse. I'm not telling my boss that's what I'll be doing, but there may be some people who would look at this scenario, and where consultation is not carried out and consent is not obtained, employees can successfully claim the deducted or retained salaries through a court process. A court has power to issue injunctions to stop unlawful variations of terms of service, as well as unlawful declarations of the redundancy. And that is where it stands in terms of just some of the issues you should be looking out for. I see my colleague here, Jackie, is very attentive, because it has hit home here at the Nation Media Group. Some of these measures have also had to be put in place for the next 3 months.